So, attorney, I'm from BPO company. There's a client involved wishes to remove a certain employee without valid reason or proper documentation. So, of course, as a HR, we know that prior terminating a certain employee or disengaging from the account, it should be documented, at the same time done in good faith. Since the client doesn't have any evidences or even proof, what are the best practices that we need to abide for us to avoid any labor disputes? My current process is that I place that certain employee on bench. We are paying that employee unlimited. There's no limitation yet since she's not at fault. So is there any other way that we can avoid those expenses incurred? Po.
Yes.
Thanks, attorney, in advance.
Yes, meron tayong tinatawag na floating status which you can explore, no, if applicable. No, ano itong floating status? Maraming tawag dito. Putting a person on reserve status, yung katulad ng ginamit mo, putting person on bench. Wala tayong malinaw na batas dito, but there are jurisprudence on the matter and it is recognized by the Department of Labor and by our Supreme Court. No? The closest law that we have on temporary layoff or floating of employees is Article 301 of the Renumbered Labor Code. Pero hindi po ito exactly applicable, no? By analogy lang. Article 301 talks about suspension of operation. So when a company suspends its operation in good faith for whatever reason, because of a calamity or because of some valid reason, not really its fault, no? The affected employees can be placed on a floating status under a no work, no pay arrangement for a maximum period of 6 months. Pero ang wala tayong batas is what if the company continues operating, no? Tuloy-tuloy naman yung operation, hindi naman siya total shutdown or total suspension of operation, and then only selected employees are involved, no? So dito napapasok yung jurisprudence which is recognized by the Supreme Court as a management prerogative when exercised in good faith, no? And this has been recognized in several industries, particularly in the private security agency industry, no? For example, walang post, no? Kasi ganyan sa mga service contracting, sa mga job contracting nangyayari yan, no? And BPO, although kayo ay information technology enhanced or enabled services, essentially kayo ay service or job contractor din. Using this same principle that is being used in the manpower industry, you can explore putting employees on floating status under a no work, no pay arrangement. However, this prerogative to float employees or to put them on reserve status should be exercised in good faith, no? Dapat walang bad faith, talagang there are circumstances na unavoidable, no? Of course, maganda yung ginagawa nyo, no? You pay the employee kahit wala siyang work, no? But the general rule really is no work, no pay. That is the accepted principle in the Philippines, in Philippine labor law. Now you have to orient your employees about this process, no? About this stage, no? Kailangan dun pa lang sa onboarding ng employee, sinasabi nyo na may mga situations na ganito, no? We have to satisfy our clients. Pag terminate nila yung service agreement natin, wala tayong business, baka magsarado yung company natin. So minsan, no, yung mga clients natin, we have to appease them. We are not terminating you, but we have to place you on bench or on a reserve status, and under this situation, it's no work, no pay. We will try our best to look for a new account for you wherein you will be rendering services. And under the law, the maximum period for this floating status is 6 months, no, or 180 days. Beyond the 180 days, no, at hindi nyo pa rin pinapasahod ang inyong employee, it will be considered constructive dismissal. So magkakaroon kayo ng kaso sa labor, no? Magkakaroon labor case kayo for constructive dismissal because ang maximum period for floating status is 6 months of no work, no pay. Ang advice ko dyan, before mag-end yung 6 months, on or before the 5th month, sabihin nyo na agad sa employee kung ano talaga, kung mariredeploy siya, kung marire-employ siya, mabibigyan siya ng job or hindi. And isettle nyo na. Padala nyo na siya ng 30 days notice, notify all, and give the corresponding separation pay if you cannot really find any work for that employee. Okay?
Attorney Paul, thank you so much for that information. Just a follow-up question, if it's okay with you. Is it fine